All right, we have a lot to talk about. You are at the center of maybe one of the biggest issues facing college sports right now, and that is the challenges to the NCAA's longstanding eligibility rules. Let me just set the basic groundwork, and then we can talk about your representation of Diego Pavia and now a number of other athletes challenging these rules. But the basic rule has been that college athletes get 5 years to play 4 seasons of competition. And once your 4 seasons are up, you're done. Or once you've been there for 5 years, you're done. And there have been exceptions to that. And we saw a lot of exceptions to that, like we saw a lot of exceptions to a lot of things during COVID, so that students were given an additional year or an additional season, depending on their circumstance. And that set of rules and some other related rules and the JUCO rule, but that basic set of rules has now been under attack, I would say relentlessly for the last year plus, really started in large part by you and Diego Pavia. So can you talk about Pavia's case, why he brought it, and then we can talk about the specifics of the more recent consolidated case and the preliminary injunction you sought and everything that's come from that and all the different changes that have been made. But let's start from the beginning with Diego Pavia and why that lawsuit came about and what you were trying to accomplish.
Sure. I think if it's okay, I want to reframe the issue a little bit because we
Okay.
don't think it is relentlessly attacking the NCAA's eligibility rules. We think of it as looking at the framework the NCAA has created and assuring that everyone is treated fairly within that. The NCAA has said for years, you get 5 years to play NCAA sports. But then they say one of those years you can't actually play against another team. You can only practice and play against your own team until COVID happened. And then they said, we'll give everyone 5 years to compete against other players. And then once COVID ended, if you played during COVID, you get the fifth year. If you started after COVID, you don't get the fifth year. And there's a lot of inconsistency there. But back to your question, how things started with Diego. Diego Pavia played at junior college. He played at New Mexico State, and then he played at Vanderbilt University. In junior college, he had no opportunity to earn any money for use of his name, image, and likeness. He got to New Mexico State, he earned a little. He got to Vanderbilt, he earned a little more. And then he beat Alabama, the number one team in the country. And under the NCAA's rules, where they counted junior college, where he had no earnings against his time competing in NCAA sports, he'd be out of eligibility. And we looked at that and said that was fine back before athletes got paid. But in light of Alston, in light of athletes now getting paid millions of dollars while playing NCAA football, that just wasn't fair. And that time should not count against it. And so we approached it from an antitrust perspective and said the NCAA is essentially boycotting former junior college players, not for their first year, but after they've spent a couple of years in the NCAA. And that led to our first lawsuit.
And so for Diego in particular, he at that point played 4 seasons according to the NCAA's rules, two at junior college, one at New Mexico, and then one at Vandy. And he hadn't taken the 5 years though, right? Is that the and so he
Yeah.
was challenging, he wanted to be able to play another season, but he would not need an exception for an additional year because COVID was mixed in there. But right, that's so he was only challenging one aspect of it.
He was challenging multiple aspects. He was challenging the concept of whether JUCO counted towards your 5 years because he had 2 years at JUCO. One of them, the NCAA said, that's COVID. We're not going to count that anyway. So you don't have the right to bring that challenge. And so then he still had two challenges. One was to the JUCO rule, and the other was to 5 for 5 and the concept of redshirting. We just didn't get to that in his case.
So you didn't get to it in that case, but now we are getting into it in these more current cases. But then tell people what happened. And I think people probably who are college football fans saw Diego Pavia on the field and are now seeing his name in NFL circles. So tell us what the court ruled, why they ruled it, and that it's all now relatively ancient history and granting an injunction and the Sixth Circuit saying it's moot, but it's certainly relevant in terms of the evolution of these cases and the NCAA's response, and then these new consolidated cases that you brought in injunctions and the broader challenge. So if you can just kind of give a quick summary of what the courts did with the first Pavia case.
Sure. So in the first Pavia case, we brought a motion for a preliminary injunction for violation of the Sherman Act based on the NCAA's decision to count time in JUCO against your 4 seasons of competition at the NCAA level. The federal court found we had demonstrated a likelihood of success on the merits on that claim. And the court did his own research. The judge focused on one particular aspect. He asked the NCAA, why is it that an athlete who goes to a military academy prep school, who plays military academy prep schools, play junior colleges, but if you go to the military academy prep school, that does not count as a season of competition, even though you're playing junior colleges. If you're at a junior college, that does count. How is that fair? How is that reasonable? And the NCAA did not have an answer for that question. And so the court ended up ruling that we were likely to be able to show a Sherman Act violation, and he granted Diego another year. And then the NCAA issued a waiver granting all former junior college players whose eligibility was about to expire the same leeway, that they would get another season of competition.
So, and that was where it was specific to Pavia's circumstances. It didn't mean that every junior college football player would automatically get another year of eligibility. It had to fit the circumstances where you still had that 5th year, but hadn't played the 4 seasons if you didn't count that one JUCO year. And so there were a lot of lawsuits that filed saying we want the Pavia waiver, and some were granted, but a lot were not. And then those were litigated separately. One, just to back up for a second, and I know you've discussed this in a couple of other interviews you've done, but I do think it's interesting how you got involved in this. So can you just tell folks what led you to being Diego Pavia's lawyer and now many other college athlete lawyers, and now being one of the biggest names in sports law? I think you probably 5 years ago would not have expected to be in this role right now. I think that's fair to say.
Yes, it's definitely fair. My background is complex commercial litigation. Prior to this case, the only sports law I had done was representing the NCAA. I had defended the March Madness trademark for the NCAA at the Fifth Circuit, but that's 20 years ago now. I am a Vanderbilt alumni. My wife and I were watching Vanderbilt play Alabama in, wow, how many years ago now? I guess that's back in 2000. Vanderbilt upset Alabama, and Diego was the quarterback. My wife is also a lawyer, and we were talking about NCAA antitrust laws. And I told her, I think this guy is the perfect plaintiff to challenge some of what I think are blatant antitrust violations by the NCAA.
And was this a regular topic of conversation? Do you and your wife typically sit around talking about antitrust law? Because my wife is a lawyer too. So we'll talk about that stuff sometimes. But were you guys, is she an antitrust lawyer, or is she involved in the space?
No, she's a human rights
Okay.
lawyer. She doesn't practice in the US at all. She's from New Zealand. So no, antitrust law is not a regular topic of conversation in our house. It was just something that every once in a while you'd see an article and I'd say, hey, I think the NCAA has real problems here, but I never thought I would be the one pursuing a remedy. So she told me to call Vanderbilt and ask Vanderbilt for an introduction to Diego, because again, she's from New Zealand and they have a different sports setup. And I told her Vanderbilt will never do that. They're part of the NCAA. I can't call them and say, I want to sue your organization, introduce me to your quarterback to do it. So it was just another one of those interesting conversations you have with your wife and you move on with life. And then we were in Nashville a few weeks later for the Texas Vanderbilt game. And we ran into Diego in the lobby of the team hotel where we were staying. And she told me you should go talk to him. And so I walked up, introduced myself. I asked if he was coming back, and he said, I'd love to, but I'm out of eligibility after this year. I told him, I don't think you should be. If you have any interest in suing the NCAA to get what I believe you deserve, another year of eligibility, I'd love to talk to you about it. And I won't charge you anything for the representation. And he asked if I was serious and got my phone number, and we went from there.
Unbelievable. chance encounter after a chance conversation with your wife that leads to all these changes. And it's also interesting that back in the day, representing a college athlete as a lawyer without charging them could be its own NCAA violation as an improper benefit back when we're looking at these things. But okay, so then you take the case and
And I'll add to that. We actually thought about that. And the engagement letter did have the possibility that I could make money on a contingent basis based
yeah.
on certain circumstances that we didn't do. And then obviously it's an antitrust case. The NCAA someday should have to pay all of the attorney's fees.
And it would have been interesting if they then not only denied his waiver, but then also punished him for improper benefit by using you to bring the lawsuit. But anyway, but we're not there, and we can. These are conversations I could have with my wife. Maybe you can have your wife that would be interested, but I don't know how many other people would be. But and then did Vandy have a strong reaction? Because I know a lot of these schools are in these weird positions where they are part of the NCAA and they have agreed to these rules, but then they benefit from having their athlete come back and have an additional year of eligibility. So they're often in support of this. And so I was Vandy pleased to hear, or did they not communicate with you? Or
their position was this is an athlete's decision, and we support our student athletes in whatever they want to do. We're not taking a position on the merits of the lawsuit, but the football coaches said they would love to have him back if he can come back.
Yeah.
But they were not going to participate in the lawsuit. They did. I think the coach did sign a declaration saying, we've got a roster spot, but we need to know right away, or we need to recruit a quarterback.
And that ties into the irreparable harm and having to get the immediate relief. And then, all right, so then fast forward, it gets appealed to the Sixth Circuit. The Sixth Circuit dismisses, saying it's moot because they've already granted, the NCAA has granted this blanket waiver, the Pavia waiver, that certainly includes Pavia. And then all these other cases are being filed, being brought. And then tell us about the other athletes that you were representing and how we ended up with this consolidated case that is now moving forward back in the Middle District of Tennessee.
The NCAA and my team were both frustrated with the Sixth Circuit. We had collectively agreed to put most of the other potential litigation on hold and try to get a ruling from a circuit court on some of the key legal issues. Are the rules subject to the Sherman Act? Are they commercial in nature? And then within that, what is the standard for likelihood of success? Because I believed that if the Sixth Circuit ruled in the way I think they ultimately will, that the rules are commercial in nature and there is a likely antitrust violation, then we'd likely be able to settle the case with the NCAA. We'd be able to get rule changes. And the sooner that happens, the more it helps students. These athletes are not looking for money. That's not their primary motivation. They want to play. They want the benefits that come with playing, but that's what they want. And the longer this takes, the more athletes don't get to play. We will certainly be trying to recover damages for them. We think they should get all of the money they were entitled to, but that's secondary to all of them. And so we thought getting to the Sixth Circuit early, and the NCAA agreed and wanted the same thing, would provide clarification. When the Sixth Circuit ducked and said, we're going to send it back for more factual development, it meant that we couldn't sit back with all the other cases anymore because those athletes have expiring eligibility. So we filed a class action on the intersection between the 4 seasons of competition and the redshirt rule with the 5-year eligibility period. And then we consolidated into Diego's case a lot of the other junior college athletes who were independently seeking the same relief that he was.
And so then explain to folks again who don't know the intricacies of it, how this case is broader than the Pavia case, because you mentioned you've got the 5 years and the redshirt part, but explain what this is seeking to prohibit the NCAA from enforcing.
So right now we've got 2 separate cases, and they are completely separate and distinct paths, even though they're both in the Middle District of Tennessee. They're consolidated for discovery. One is focused on Diego's issue. It is junior college. Should junior college count or not count as NCAA competition? The other newer case, I would say the broader case, it impacts a lot more athletes, is not limited to football. It's for all sports. And the question is whether the NCAA, under antitrust law, can tell an athlete you have 5 years of eligibility, 5 years to go to school, 5 years to be on a team, 5 years to practice. But for one of those years, sit on the bench. When the games start, you can't be part of them. Unless you play football, then maybe we'll let you play 4 games, or this year 9 games, but then go back to the bench. And there doesn't appear to be any rational basis. That's not the test, but there's no pro-competitive reason that helps the players to say, be on the team, do all of the work, but don't play, don't compete. And so that's the challenge there.
And if the NCAA does pass the new proposal that you get 5 years to play and you can play 5 seasons, you might only play four if you're hurt or something happens, but you get the 5 and 5. Does that moot your case, or do you then say that they should get 6, or that?
Neither. So we're not asking for 6. We won't ask for 6. Our position is the NCAA can set a reasonable eligibility period for a college athlete. They've said it. It's 5 years. So we're seeking 2 things in the case. The first is a rule change. So they'd give us the rule change. It would moot that part of the case. And going forward, all athletes would be treated appropriately. There'd be nothing left. But for the athletes from the high school graduating class of 2021, they didn't get 5 years. Everyone before them in the recent history got 5 years because of COVID. If you graduated in 21 from high school, you did not redshirt, you finished college in 25. And so they did not get that 5th season of competition that we believe they're entitled to under the law. And so the case would remain for damages for those players.
For the past, yeah, for the past athletes.
And then for the high school class of 22 that's about to graduate from college, they're in limbo right now because the NCAA said this week they're going to change the rule, but they're not going to change it for any of them. So you've got athletes right now in spring sports, still in the middle of their season. The NCAA is going to change the rule, but say we're still not letting you play next year. And so that's something we're exploring right now. There undoubtedly be many legal challenges if they follow through and don't apply it to all athletes who are still within their 5-year window immediately.
And then, but once the past class is compensated or given damages or whatever the case may be, and then this class is dealt with moving forward, so you think that you, at least under your current theory, wouldn't challenge the 5 and 5?
No, we've been pushing for 5. That's exactly what we've asked. So if the NCAA does it, then no, there's nothing there for us to challenge.
And then do you think the NCAA has a strong chance of succeeding on other lawsuits that will surely be filed? Because even if it's not you, someone's going to file a case that their athlete played for 5 years, but why shouldn't they get a chance to play for 6? And they were, whatever circumstances happened to them in one of those years or 2 of those years, and so they want the ability to play for 6. Do you think the NCAA has a legitimate case there? Because you said they can set reasonable limits, but why is 5 more reasonable than 6, than 8, than 10, than 2?
I think they win those cases because of the flip side. Why is 6 more reasonable than 5? The court's job is not to micromanage NCAA rules. The NCAA has set a framework, 5 years of eligibility. So we've stayed within that framework to say, you set it at 5, you need to let everyone play their 5. If they set it at 6, then it would be the same. We'd say, you've got to let them play 6. If they had set it at 4, they wanted to go backwards, I think they could have done that and they would likely have won the lawsuits. So I don't think people are going to succeed. Someone will challenge it, and that's the way common law evolves. The NCAA situation is really interesting from a legal perspective because usually common law evolves over decades in an industry. But the NCAA essentially had common law frozen because of a non-existent antitrust deference and almost an exemption that courts had given them up until the Alston decision. And then once Alston says you don't need to give them deference, and then you start paying players, all of a sudden, case law that would have evolved over the last 40 years is all happening at once. It'll work out. It's hard for the NCAA right now. They're facing a bunch of lawsuits, but over time, there will be less and less lawsuits as we get circuit level precedent.
So on the current case and the motion for the memo in support of the motion for TRO and preliminary injunction, I have two questions about that. One, in the beginning, this was what you filed this back in, so it was right after Christmas. And so you open, was it your idea to put
The
what is
poem,
it, the poem in the front?
yeah,
Yeah, it's I don't know that how many times I guess I'm sure there's lots. That's not like I read everybody's motions, but do you want to describe for those most, I would imagine most people listening have not read this document, or at least have not read it page to front to back, but can you explain what you included, why you included it?
sure. So it was the week before Christmas, and the NCAA issued a waiver. They were allowing former professional basketball players to come back and play college basketball. And they were not going to count the years they played professionally as seasons of competition. They counted them against their 5-year clock, but not as a season of competition. Now, meanwhile, you've got college athletes who played. I've got one client, he played 6 minutes as a walk-on freshman, and they count that as a season of competition. But the guy who got paid professionally to play 50 games, he didn't get that counted against him. He gets an extra year. So I found that incredibly hypocritical. And given the time of year, these cases are interesting. People read them in the media, and we thought this was a good chance to draw some attention. And so I opened the motion with a poem. It was the night before Christmas, which is when we were filing it, and explored how the NCAA's rules struck me as completely unfair through the language of the poem.
It's a wonderful example of legal creativity and creative writing. And I imagine it gave the clerk who read it or the judge at least a smile. And what I appreciate is that you didn't tie that in throughout the entire memo. So each subheading wasn't for dancing, whatever's. Not that there's anything wrong with doing that, but this seemed like a nice balanced approach. But getting to the substance of it, the NCAA's one of their primary arguments is that, and I'm reading from their brief, if taken to its logical conclusion, plaintiff's position would permit student athletes to compete in, at minimum, 18 seasons of intercollegiate competition, 2 seasons of JUCO, 4 seasons in D3, 4 seasons in D2, 4 seasons of NAIA, only then to matriculate to a D1 institution at roughly the age of 32 with a fresh 4-season clock. So that's one of their lead arguments. That's on page 3. Because this is their response to you, and I haven't seen your filing in response to that yet, but what is your response to that particular argument?
It's great hyperbole, completely disconnected from the real world. So first, as a practical matter, no one does that, and no one would do that. If you're good enough to play Division I football, you're not going to play 4 years of Division III to get good enough to get to Division II, and then 4 years of Division II to get good enough to get to Division I. There is not likely to be a single person that effectively would ever go that route. But beyond that, from an antitrust perspective, it wouldn't work. So to have an antitrust violation within the rules, you have to have a substantial economic impact. For junior college football players moving to Division I, that happens a lot. There's a substantial economic impact. There are not a lot of Division III football players moving to Division I, a handful a year. There's no significant economic impact. The NCAA would not lose that challenge. Same thing for Division II. And so it's something they put out there so the media can run with the numbers and say, oh, how horrible this would be. A legal challenge would not succeed. And as a practical matter, it would never happen. So it's hyperbole that it's not real.
Okay. And then related to that, there's the issue of proving the relevant market, and the relevant market has been a significant issue in many of these eligibility cases. And one of their arguments is that you haven't sufficiently proved what the relevant market is, and there's suggestion that it is broader than could be broader than Division One football. In some cases, it's defined as FBS football, and then in some cases, they argue it could be NFL football as well, and that it's the plaintiff's burden to identify the relevant market such that you can prove that there are anti-competitive effects, because you have to prove anti-competitive effects in a relevant market, not that market power itself is a specific requirement for Section 1 cases. But what's the plan there? What's the approach there? Because the Alston case, as the Supreme Court said, both parties agree for sake of this case on what the relevant market is. And then there are other cases out there that say the plaintiffs have failed to prove it. Others have said you don't need to prove it because the anti-competitive effect is so obvious. What's the strategy here?
It's an area of incredible frustration to me. And I think the NCAA has done a great job. I'm sorry, hold on one second.
Yeah.
Okay, I got to finish this and then I can come do that. Okay.
We can wrap up. We can wrap up in another
Oh,
minute.
no, I'm fine. My daughter had a question and I answered it. Okay, so let's restart that. So I heard your question. I'll just start answering over again. So the market definition is an area of incredible frustration to me. I think the NCAA has done a wonderful job of hiding the forest through the trees, and judges have gotten down to the nitty gritty and missed the big picture. The point of a market definition is to be able to examine whether there is market power. That's self-evident in an industry where the NCAA is the industry. There is no competing college sports organization. There is nowhere else an athlete can go and play and get paid while being in school. That is the market. The NFL is not a substitute. The NFL takes such a small fraction of players. And so the NCAA has used this market argument to delay cases and really put off the inevitable. When any normal average person looks at this, they quickly conclude this is a market. You don't need economic analysis from experts when a layperson can look and see this is the market. NCAA Division I sports is a market. And the NCAA has monopoly power within it. It's undisputed. So I'm not concerned about the market definition. I don't think we need to show it, but we are having experts do the type of cross-elasticity analysis the NCAA has rejected, has demanded, even though we don't think it's necessary.
And do you think it's necessary to define whether it's FBS football versus Division One football, or whether it's Power Four football or Power Two, that whether these are submarkets?
So the reason I don't think it matters, the NCAA controls all of them. So they've got market power, whether it's just FBS, whether it's all of Division One, it's still the NCAA. It's the same rules, it's the same control, it's the same impact. When you're looking at your damage analysis, those submarkets matter. But as far as does the NCAA have a monopoly and monopoly power? Yes, they do.
I guess the equivalent would be asking whether the AFC East and the NFC East are different submarkets. It doesn't really matter for purposes of the overall analysis. But and I'm not suggesting that they're the same thing, and I'm not suggesting that the model is the same and anything is the same other than they're both playing football. But and they're divided up in certain ways. But the other couple of quick issues to wrap up on this threshold issue that the NCAA has been fighting for a very long time on whether this is commercial activity. Again, for those who are not as well versed, antitrust law only applies if it is interstate commerce, and the NCAA has argued for, again, in lots of different areas, but particularly with eligibility rules, that they are non-commercial. And because they are non-commercial, antitrust law does not apply at all. And the twist in the last 5 years is now that college athletes can receive compensation for their NIL and now can receive direct compensation from institutions, that it seems to add a commercialization aspect to it. In the ranking of arguments you feel strongest about? Where does the commercial versus non-commercial? Because there have been some courts that have concluded that some of this is non-commercial, even recently. So where do you feel on that argument, or how do you feel on that argument?
I think it's over. Every circuit court that's looked at it has ruled that it's commercial. You got two circuit courts. It's the Third Circuit and maybe the Seventh that have explicitly done that in majority opinions. Sixth Circuit in concurrences, they've said it's just obvious. If an athlete is excluded from a marketplace where they would be paid, and you're doesn't matter what you call the rule, an eligibility rule or anything else, you're prohibiting them from earning income. That's commercial. I don't think the NCAA will keep arguing it until the U.S. Supreme Court rules, but I think there is zero chance that they win that.
Okay. And then where do you see this playing out, or how do you see this playing out? Because there's the NCAA, as has happened in a lot of these big antitrust cases, is they get challenged on something, they're either losing or have lost, and so then they change the rule. And then by changing the rule, they eliminate much of the litigation, but then maybe some additional litigation spawns from it, and then actually relies on that change to say, look, you changed that rule, why can't you change these other rules? If this was so important to you, why, if you thought the survival of the NCAA depended on that rule and then you change that rule, why can't you change this rule? If the 5-5 does become a reality, and again, the classes of plaintiffs, the years of plaintiffs we talked about are compensated, or they receive whatever remedy they that is appropriate. Do you see any path to stability beyond that? Because the 5-year eligibility is a big part of what's going on now, but it's also within transfer portal, within NIL restrictions, with the College Sports Commission, and questions of athlete unionization. So what do you, I know you have a narrow slice of this in an antitrust case involving one specific set of rules, but do you see a path for stability for college sports?
I do. I think it's going to take a little time. The transfer rules need to be fixed. I think, and it's been discussed at the congressional level, I think one transfer makes sense. If your coach gets fired or leaves, maybe you get a second one. Other than that, you need to sit out a year. No one ever required the NCAA to change the rules the way they did on transfers. They had to loosen the transfer restrictions. They didn't have to say there are no restrictions. So I think they could make that change without Congress and likely survive antitrust challenges. But that will do a lot to stabilize the market when there are some rules around transfers. Multi-year contracts that are enforceable will do a lot to stabilize the market. I don't think unionization's a possibility in the current landscape because many states, you can't have state employees unionized. The CSC, I think, is hugely problematic. I don't think the College Sports Commission will survive. I don't think there will be many legal challenges. I think as soon as they invalidate a third-party agreement, then they're tortiously interfering with someone else's contract who's not part of the NCAA. Who is the CSC to determine what is fair market value for an athlete's name, image, and likeness? There's an open market out there. If people connected to the University of Alabama are willing to pay $2 million connected to a player's name, image, and likeness, then why shouldn't people connected to another school who say, we want to pay 2.1 million? How can you say that's not fair market value when there's a competitor in the same range? But that appears to be the goal of the College Sports Commission, and trying to distinguish between legitimate NIL and pay for play. I'm not sure how that distinction exists. An athlete's name, image, and likeness is explicitly tied to their performance on a football field or a basketball court, and their value is what the market will bear. So I think those limitations are going to continue to face litigation that the NCAA will lose.
And do you think, is there a way that they can put a limit on compensation? Because through the House settlement, they clearly are trying to achieve what pro sports have achieved through collective bargaining, which is to have a salary cap and then allow the athletes to do their own NIL deals, but to ensure that those NIL deals are not used to circumvent the cap. But without a collective bargaining agreement, without a union, you don't have the same antitrust protection. So they tried to achieve this antitrust settlement, but as you said, that doesn't bind. They're not the third parties are not bound by that settlement, even if the settlement did cover all of this. But can the
In
NCAA do
pro
anything?
sports,
What's
in pro sports, there's no limitation. If a fan of a team wants to pay one of the players an extra $1 million to sign autographs, I don't think there's anything in the NFL rules that prohibit that. I don't think they could.
No, but they could prohibit it if they were designed to circumvent the cap. So in a fan case that a fan says we're willing to pay you $1 million because it's worth $1 million to us to have you come to our house and sign autographs for my kid's birthday. But if it is a third party is being alleged with the LA Clippers, who they're giving
As
an
the
NIL
owner,
deal,
yeah.
yeah, to try to go around the cap, they are trying to prohibit those. So they do have some restrictions, even if the third party say, why should I be prevented from spending money on Kawhi Leonard? I love Kawhi Leonard and I want to give him a bunch of money. The NBA says we have a cap. So there are
I
some limits.
there are, but I think that issue came up because it was the owner's company. The owner of the Clippers, it was the one, his company
Yes.
was the one paying. I think if it was a Clippers fan, I don't think it's come up, but that's the equivalent. And
Yeah.
so I don't know how the NCAA stops that. I think eventually there will have to be some creative structure where the athletes are employed by some entity that's not the schools and is not the NCAA. But if it's a conference, if it's an entity, whether regional or nationwide, created for that purpose, you can have some sort of collective bargaining because absent congressional action, which is really hard to get consensus,
Yep.
or collective bargaining, then limitations on compensation are antitrust violations. It's just,
Yeah.
it's the way it is.
But so I'm curious that you're willing to accept a limitation on the eligibility clock as long as it's reasonable, but not on the compensation amount.
I'm fine with a limitation on the compensation amount that schools pay players. I think the problem is when they're trying to limit compensation that third parties pay
Got it.
players by saying the
Yeah.
third parties have a relationship to the school.
Got it. Got it. Yeah. Makes sense. That's super helpful and fascinating. And it's fascinating as we all have conversations with our wives or our partners or our friends about the future of college sports and antitrust. So it's a great time to be an antitrust lawyer or an antitrust professor. But last quick question. At the end of a lot of my interviews, I like to ask about the best advice that somebody has received or the advice you've used the most that you've received. And my answer is my dad told me lefty loosey, righty tighty when I was a young child, and I still use it every time I have to figure out how to loosen or tighten something. It is not the most substantive or meaningful, but it is the piece of advice I use the most. So what is the piece of advice you use the most?
Oh, wow.
I can tell you've
Well,
never
if
listened
we're,
to the end of the podcast because you're caught by
yeah,
surprise on
if
this one.
so, I'll tell you one I tell my daughter
Yeah,
every day because she's learning left and right.
yeah.
If you just put your
There you go.
fingers up where you've got an L, there's your left.
That's good. That's good. That's a good one. Actually, I used that for a long time. My version of that now, as I've gotten older, is that when you have to figure out where your bread plate is and where the drink is, you
Yep.
put up the B and the D. That's, but I'm not often at dinners that frequently where I need to figure out which one's my bread plate and which one's my dinner plate. So I use the lefty loosey, righty tighty more. But thank you, Ryan. This is awesome. This is super informative, and you did such an incredible job of breaking down the issues clearly. And appreciate all that you do, and wish you the best of luck as this stuff moves on. What is the next state? What's the next step? I know the last I checked, there was a trial date set for 2027. What's
So
next?
there'll be stuff before then. The JUCO case for 28 athletes hoping to play next year. We've got a motion for a preliminary injunction that's been fully briefed and argued for more than almost 3 months now.
Yeah.
I am hopeful for ruling any day.
Yeah.
And then I think once the NCAA formalizes whatever they're doing for their 5-5, we'll have to address it, but we'll see what they do. Thanks so much for having me. I enjoyed it and would love to come back again as stuff
Yeah.
continues to
Love,
develop.
love to have you. Love to have you back on. This is great. Thanks so much, Ryan.
Thanks.
And thank you all for listening. And thanks as always to my loyal sponsor, the Tulane Center for Sport. See you next time on SportsWise.